appeal in the matter of Abbott Diabetes Care Inc and others, and Dexcom Incorporated and others.
Yes, Mr Lewison.
Thank you, Lordship. I appear with my learned friend Mr Austin, and
Yes.
Dr Barron appears for the controller. And on this side of the court, we appreciate the role of the controller in seeking to fulfil his defence of the public interest, but also in the present case in acknowledging the shortcomings in the judgment from Abbott's perspective. And your Lordships would have seen the controller has raised two respondents' notice type arguments in relation to grounds 3 and 4, which he has accepted have force. And we have supplied a short supplemental skeleton argument dealing with those points at Core 13, which the court has permitted. And for obvious reasons, the focus of my submissions this morning will be on those grounds, and we hope that the court has found it helpful to have a preview of what we're intending to say.
Yes, certainly.
I'm grateful.
I should have said that we've read the skeleton arguments and the supplemental, we've read the judge's judgment, and, well, speaking for myself, I have looked at the patent in suit and Heller. I can't say I've read them cover to cover.
I'm grateful. Well, my route map for submissions today, it will be as follows. I'm going to start with a brief chronology.
Yeah.
Then I'm going to deal with the effects of grounds 6 and 7 in general terms. Then I will look at the common general knowledge and the skilled team as defined by the judge. Then turn to the patent. Then look at Heller, and then go to the reasoning of the judge by reference to the remaining grounds. With a fair wind, I'll also attempt to deal with my Lord Justice Arnold's question of Monday morning. And with a fair wind, I'm hoping to be sat down by lunchtime, and we're both hoping that we can complete the appeal today, subject to the court. So, my Lord, starting with a chronology, this case is part of global litigation, which was initiated by Dexcom, who launched infringement proceedings against Abbott in Germany in July 2021. Abbott responded with the current proceedings, seeking to revoke the Dexcom patents that had been asserted in Germany and asserting patents of its own. Abbott also sought expedition because of the German infringement proceedings being brought by Dexcom, where there was no opportunity for Abbott to challenge the validity of the German equivalent patents. There was a hearing in relation to...
There was the opportunity, but only in parallel proceedings, which would be slow.
Yes, indeed. Mr Justice Mellor refused the expedition application, but he did say at paragraph 61 of that judgment that this was with some regret because he found that the authorities did not allow him to assist Abbott in its attempt to invalidate the English equivalents of the patents being asserted against it in Germany. And I make that comment only in the context of the delay, which I'll come back to. This was the second trial in the series of trials that took place, and as your Lordships will have seen, it occurred in April and early May 2023, so almost 2 years after the issue of proceedings. And then the judgment, as your Lordships will have seen, did not come until the end of June 2024, some 13 months after the trial. The judge found the 044 patent invalid and not infringed by Dexcom's G7 product. The judgment in Trial A, the first trial, was also similarly delayed, and we say that the delay in both cases was regrettable, particularly in the circumstances of the expedition application.
Was Trial A also heard by Mr Justice Mellor?
It was, yes. And your Lordship should know that the appeal on that case, where again the controller represented the public interest, was heard last month by this court, but under a different constitution. And I think judgment is pending in that case.
Yes, and I asked for consideration when giving permission to appeal as to whether it would be beneficial to hear the two appeals together, and I was told not.
Indeed. So going back to the first instance proceedings, the form of order hearing in both Trial A and Trial B took place in December 2024, and then it was shortly after that hearing that the parties settled the litigation globally, which by that stage covered 7 jurisdictions and some 50 patents. So the position your Lordships find yourselves in is that Abbott now seeks to correct the judge's error in invalidating this patent. And your Lordships should know, I think we refer to it in our skeleton, that prior to settlement of the proceedings between Abbott and Dexcom, the EPO opposition division had issued a positive preliminary opinion in relation to this patent in the face of Dexcom's opposition. Dexcom obviously then withdrew, but the EPO decided to terminate the opposition. It's allowed to continue the opposition if it wants to. If it feels there are issues, it needs to.
The opposition in the EPO was also based on Heller, was it?
There were a number of pieces of prior art that they did seek to bring Heller in towards the end, but there was the main opposition was there was added matter. You know, all the issues were there, so there wasn't as much focus on Heller in the EPO as there was here. But anyway, the patent was upheld by the OG and remains valid in Europe. And my Lord Justice Arnold gave permission in this case, citing the inordinate delay of the judge as part of the reasons. So that brings me to grounds 6 and 7, which are the delay in giving judgment and the copying out of Dexcom's skeleton to a very large degree in the judgment. Now, your lordships have seen the authorities, no doubt familiar with them. I'm not going to go to them. The authorities of this court recognise that neither practice, that is to say copying out skeletons in a judgment, or delay on their own can justify overturning a judgment. And in each case, it's necessary to look at the substance of the judgment and work out whether the judge has actually gone wrong. In our submission, it's much less easy to tell that the judge has got it right if he or she has merely copied out the submissions of one party or the other. And equally, it's much less easy to tell the judge has got it right where it's taken months and months to deliver judgment because the weight of having seen the witnesses, etc., fades over time as the authorities recognise. So in this case, we prae both factors, and we submit that it's fairly clear what has happened in this case. The length of time which the judge took to write the judgment has caused the judge to forget parts of his decision and has led to a material inconsistency between the construction he adopted on infringement and the construction he applied for the purposes of validity.
That point surely would be just as valid if he delivered judgment the day after the trial ended.
It would, which is why I say that they're not really standalone points, but they are explanations for the errors which we say the judge has made and which indeed the controller recognises. And we say what's happened is the judge has reached his conclusions on different parts of the judgment at different times. It's difficult to tell which came first, but the reasonable assumption is that he dealt with construction first and then came back to obviousness later. And as a result of the delay in dealing with obviousness, he felt it was the easiest thing to do was to reproduce in large part the submissions of one party. But because of the delay in dealing with obviousness, he failed to apply the construction he'd reached.
Well, that I understand. I mean, suppose he had prefaced part of the judgment you criticised by saying, "I accept the submissions of Mr. Purvis, which were as follows." Could you complain then?
Well, it all depends on whether it's apparent that the judge has considered both sides of the arguments and has applied them correctly.
He set out your submissions in some detail.
Yes, he did.
So this is not a question of a judge ignoring one side's submissions.
No, and as I say, I'm not relying on these grounds on their own, but we say they partly explain the errors that we say are apparent on the face of the judgment. And we say if he'd been consistent, he couldn't have found that the patent was limited to manual insertion, but nevertheless invalid over Heller. And that's the core of our appeal.
Yes, well, that's as it were, a freestanding point.
Yes. And that's for two reasons. Firstly, that case was never run by Dexcom. And also, as a result, there was no evidential basis for it. And I'll come back to that in a little more detail later. So, my lords, that's what we say about grounds 6 and 7 and how they fit in with the other grounds, particularly ground 4. So with that, I was going to turn to the judgment and the technical background. And before the judge and before your lordships, there's no real dispute over the common general knowledge or the skilled team. For today's purposes, what matters is that the skilled team included a mechanical engineer, and that is identified by the judge in paragraph 49 of the judgment. And he then went on to deal with the common general knowledge, and he summarised that in the judgment at paragraph 68. He explained that at the priority date, the common general knowledge was that all glucose analyte apparatus. So perhaps we should. I'll turn to that, and then I can make my submission. So it's paragraph 68 in the judgment.
Yes.
Core tab 6, page 84. And what the judge was explaining there was that all glucose analyte apparatus at the priority date in the CGK had separate sensors and electronics, which needed to be manually connected by the user before use and after sensor insertion. And he goes on to note that the breakthrough in the patent was to provide an integrated unit and accompanying insertion device, which is described in some detail in the specification.
Sorry, where does he say that?
Well, I'll come on to that where he summarises what the patent discloses. But if we go back to paragraph 9 of the judgment, the judge notes that what's described in the patent led on to Abbott's flagship Freestyle Libre product, which was launched in 2014. And there was evidence before the judge to explain that it took nearly a decade for others in the market to catch up with Abbott for their fully integrated apparatus and insertion device. Indeed, Dexcom didn't launch its integrated device until 2022. Now, my lords, the requirement manually to connect the sensor and the electronics after the sensor has been inserted into the body is separate from the question of manual or automatic insertion of the sensor itself, which is the basis on which the judge found non-infringement. And just, it's quite easy to explain the point, it's about you don't have to attach the transmitter afterwards. You can say that in one sentence, but in real life, this is a seriously non-trivial task. And one doesn't really understand, one can't really see in our submission what's involved in having to attach the transmitter as part of the common general knowledge until you can see it. And we played some videos to the judge in opening to show him what the common general knowledge was. And indeed, we can make those videos available to the court if the court so wishes. But you can get a bit of a flavour of it from the judge's figure at paragraph 61 on page 83. And so this is where he's setting out one of the common general knowledge devices at the priority date. And your lordships will see right at the top of the figure, there's the sensor. And then sensor tip is identified underneath. And this is an incredibly delicate wire. It's effectively the width of a human hair or a couple of human hairs, which has to insert into the body in order to start detecting the glucose levels in the blood. And so what needed to happen as part of the common general knowledge was that sensor needed to be inserted. Then the insertion device or the needle needed to be withdrawn from the body whilst leaving the sensor in place and without damaging the sensor. And that would leave a part of the sensor dangling out of the body, often attached to the sensor support mount, which you can see at the base of the sensor delivery unit in this case. And then the patient needs to take the separate step of attaching the transmitter body, which you see underneath the sensor delivery unit, to the sensor support mount. And the user has to do that, has to put it correctly in place without damaging the sensor and without disturbing the placement of the sensor in the body, which the user's just inserted using the needle. And then the user needs to lock that transmitter into place so it's permanently attached to the body to allow the sensor to transmit. Now, none of these steps are straightforward. Obviously, if you're a diabetic patient, you get used to having to do these things, but it's quite an involved process. And so there was a very real advantage to be gained if the attachment step could be removed and a device developed which allowed the sensor and the transmitter to be inserted in one go, as the Abbott patents provide. And this is part of what the judge goes on to describe. And so when the judge sets out the CGK devices at paragraph 70, and in his table at paragraph 73, he explains how each of those require separate attachment of the transmitter in each case. And he also sets out the ways in which the sensors alone were inserted. And your lordships will see from this that there were no common general knowledge devices at the priority date referred to in this table which had manual insertion and automatic retraction, which is what the judge construed the claim in this case to require. And the other point to make here is, as the experts explained, and as the judge reflects in paragraph 70, automatic insertion, as far as the art was concerned, included devices where there was a button or a catch which had to be pressed manually to initiate the system, but once pressed, once initiated, there was no way to stop it. So you could release the spring, and the spring would then fire the sensor into the body. So there was a manual step at the start, but the experts explained that that would have been thought of as automatic insertion, because once it was started, you couldn't stop it. And typically the devices at the priority date used a spring. There was also evidence to explain about the perceived advantages of automatic insertion at the priority date. And as your lordships can imagine, some people are a bit squeamish about operating an insertion device manually themselves, where they have to press the sensor into the body, or that was certainly the view at the time. And there was a worry that if they stopped halfway, then the sensor wouldn't insert properly. If they stopped halfway because it hurt or whatever, then the sensor wouldn't insert properly. And obviously, an automatic insertion device removes this possibility. But also, it's clear, as the experts explained, that an automatic device requires a different mechanism, and that mechanism needs to then be designed to allow automatic retraction, which was also part of the common general knowledge, as well as automatic insertion. And we'll come on to the detail of that a little bit later. So, my lords, that was the background which the judge correctly explains in the judgment, but I wanted to draw those parts to your lordship's attention.
And I think he also recorded, didn't he, that your expert agreed that people always wanted to have a one-part rather than a two-part system.
Yes,
So
yes. I
said
mean,
we
we ran an argument about long felt want, and this was part of the case. The judge didn't. He said it might have been relevant to obviousness over the common general knowledge, but he didn't think it was particularly relevant to Heller. But that was part of the background. Your lordship's absolutely right. So, my lords, then we turn to the patent, and I think again, I hope I can deal with most of this from the judgment rather than going to the document itself. And that, the relevant part of the judgment starts at paragraph 110. And as the court will have gathered both from the patent and the prior art in this case, in this field it's quite common that specifications are very long, and that more than one patent application may be made from the same original specification, focusing on a different part of the disclosure. So that's why one sees these long documents. But what can be seen from the judge's summary is the following. Firstly, in paragraph 110, the judge highlights paras 1, 2, and 4 of the specification, and in particular paragraph 4, which highlights the benefit of minimising user intervention, particularly having to join the sensor to the electronics as I've described. So that's set out in the patent. And then in paragraph 114, he highlights paragraph 11 of the spec, which is where the idea of an integrated assembly which is coupled to an insertion device for deployment, is explained. And then at paragraph 120, he refers to paragraph 89 and figures 10 to 12, which follow. And you can see on figure 10 is on page 97, and that shows the part of the device which is attached to the skin. And I don't know whether your lordships will, in the present day, will recognise this distinctive round shape of the Abbott Libre product, which you may be familiar with, which you quite often see on the arms, the forearms of people with diabetes, or otherwise using them to detect glucose levels. And then in 124, the judge highlights paragraph 110, where he underlines the text, you can see, which explains again the benefits of the invention and the avoidance of the need to connect the electronics to the sensor, and the benefits of avoiding disturbing the sensor or connecting the parts that is achieved by this. Then he goes on to discuss figure 12. And again, if I can just take, he's given a key on page 99, but if I can just show your lordships the main parts of figure 12. And again, this is representative of Abbott's actual Libre product marketed after the date of the patent. So figure 12A, you can see 1210 at the very top is the housing, 1200 is the insertion device, 1220 is the cap at the bottom, which is removed before use. And then in figure 12C, you can see 1250 is the bias spring. It's difficult to get some of the detail from this, but 1270 is the sensor electronics assembly. So that's where those are. 1260 is what's called the introducer needle. So that's what pushes the sensor and transmitter into the body, and 1280 is the sensor. And so that's how it's described in the patent, which the judge refers to. And then if I can take you to paragraph 130, which is the start of the judge's reasoning on the construction he arrives at. So he calls out there that figures 12C to 12G make clear that the act of the user applying a force during the insertion process causes the spring within the insertion device housing to compress.
You push on the top of it.
Push on the top of it, yes. You push it down, and then that compresses the spring, which then allows for the insertion to take place automatically.
I have a book stand that works like that, I think.
Yes, there are many more parts to the device than just pushing it down, because it needs to release various features and compress the spring. But that, your lordship has it, absolutely. And then at 136, the judge refers to paragraphs about manual insertion, manual deployment, and he highlights paragraphs 151 and 152. And so 151 explains the insertion device may be configured for manual deployment, and then he's underlined later on in that paragraph the fact that that may allow you to press down on a spring to allow for automatic retraction. And in 152, the specification explains that if you're using manual insertion, an advantage of that is that the spring isn't under stress in the package, and the spring isn't stressed until you've placed the device in the body, and that has some advantages. So in other words, it's not cocked, is one of the other terms that's used in the art. And then at 138, the judge summarises 5 contentions made by Abbott, none of which he appeared to disagree with. He questioned the relevance of them, to the obviousness case that was before him rather than the obviousness case over the common general knowledge. But he didn't actually question any of these per se. So
This was your summary of what you said was the inventive
Yes,
concept,
yes.
presumably.
indeed, and we say the judge seemed to accept that.
Well, he doesn't really comment on it.
He doesn't really comment on it, but he doesn't say he disagrees. So firstly, in 139, we have the integrated analyte monitoring assembly. Secondly, he points out, or the patent points out, that this is the first time that a fully developed system with everything in one assembly has been proposed, and the second half of 140, such an assembly is materially different from and provides a clear benefit over the standard architecture that has been developed in existing CGM products. 141, the invention provides important advantages over the prior ARC CGM systems because it's easier to use, as we've seen. 142 is the point about saving battery life because of the activation switch, which is correct but doesn't form a part of this appeal. That's taken. It's not relevant to what's before your lordships today. And then finally, that an important part of our case below was that the Abbott patent is not simply a high-level idea. It shows precisely how to do this, how to integrate the sensor and the transmitter, how to implement it, and it provides a fully workable system that can be used. And we note here, and this is an important background to our appeal, the judge went on to base his construction of the claim on the express implementation he found in the patent, echoing paragraph 143, but then he forgot about the express implementation in his construction when he went on to look at obviousness, and we say that's one of the that's the main mistake that he made. But it seems to be his acceptance in 143 is consistent with our case and inconsistent with the approach he takes later on to inventive step. Then at 145, the judge sets out the claim and the various integers, and he goes on to deal with construction from 146 onwards. And then the two integers of the claim which were most disputed and which the construction issue turned on are 1.9 and 1.10, which he deals with at 148 and introduces them there, and 149. Then he goes through the arguments, and he starts with Dexcom's arguments at paragraph 150.
Well, one of your points is that the judge misidentified the housing.
Yes.
The housing is first referred to in integer 8, which doesn't feature in the discussion of construction.
Yes.
Was it not argued below?
It was, so I'm going to show you, your lordship. So in opening, Dexcom identified the right housing as part of their analysis. But when they got to inventive step, we say they identified the wrong housing. And they weren't talking about housing of the insertion device. They were talking about the housing of the sensor itself. And that's why they got in a muddle. In the end, the judge's interpretation of housing leads him on to decide that it's manual insertion, not automatic. So the way we characterize this appeal is that we can have a long debate about which bit of the device is the housing and whether Dexcom got it right or wrong. But in the end, the judge's construction, looking at the housing, was that it required manual insertion. And so it all boils down to that issue in the end. And so effectively, ground 3 is part of ground 4, because the reason that the judge went wrong on obviousness is because his construction of housing and his construction of requiring manual insertion was different from the approach that Dexcom was taking to inventive step. So I hope we may have to come back to it, but I hope we can avoid spending too much time on housing, and the overall point is it automatic insertion was it manual insertion, because that's the way the judge got to that. So, my lords, the judge correctly summarises Dexcom's closing in paragraph 150. And if I may, I think it's going to be easiest just to show you from the core documents how the arguments developed and where the judge did go wrong in his summary of what happened, but he ended up with by summarising the right point. So perhaps I can just show your lordships how that came about. So if we could go in the supplemental bundle, please, to tab 15.
15.
15, yeah. And this is an extract from Dexcom's closing. And paragraphs 59 and 60 of Dexcom's closing are quoted by the judge. So your lordships will have seen that already. And the important points for my purposes are in line 4 of paragraph 59, Dexcom make clear that their interpretation covers both, they don't care whether it's manual or not. They say this means that a force, whether manual or not. So their construction included automatic. And that's made absolutely clear on the last line of the page, where they say, by coupling the housing to the needle, etc., the downward movement of the needle to be achieved by the application of downward force to the housing, whether manual or automated. So it's absolutely clear that they were gunning for a construction which included automatic insertion. And then your lordships will see paragraphs 61 and 62 on the next page, where they seek to describe what they mean by operatively coupled. And then particularly in 62, you can see they talk about the two components being physically yoked together. So that was the construction they were pursuing in closing. They said that the components had to be physically yoked together, but they said that included automatic insertion as well as manual. And if your lordship just turn back to tab 14, you can see the position in opening from Dexcom, and if this is part of their opening skeleton, paragraph 81, you can see line 4. What Dexcom was saying there was that the two parts had to move in lockstep, and that you can see is similar to the yoking together they had in closing.
I beg your pardon, where's lockstep?
Lockstep's line 4 on para 81. And then para 82 on the next page, that's where they do identify the right housing. It has to be the housing of the insertion device. So they were right in opening. And then 83, they say expressly, there's no restriction as to how the force is imparted to push the housing needle configuration as it moves from first to second. And then in 84, they recognise that Abbott would be saying that the claim covered non-manual, e.g. spring-loaded insertion forces, because that is what the infringing device had in it. And so they seem to accept that, and they say the point they raise on that is that there's a squeeze, that they suggest that because there's no teaching in the patent then as to how to do this, then this has to be part of the common general knowledge, and that's the way they ran the fact that they said it covered both manual and automatic. And so in our submission, Dexcom's construction on manual and automatic didn't change. In opening, they accepted it covered both manual and automatic. That's expressly in paragraph 83. And then in closing, they also said the same expressly. And so we say the judge was incorrect when he suggested that Dexcom's submission had changed in his judgment. It it's correct that they always proposed a narrow construction, but their narrow construction didn't change, and it was always a construction. It was narrow because it required this yoking or the two parts moving in lockstep, but it at all times covered automatic as well as manual insertion. And the importance of this is that it was never Dexcom's case that it needed to invalidate a claim that was restricted to manual insertion. And that's why we say that it's not possible to find in the evidence any points in support of my learned friend's respondents' notice type arguments, because those arguments were never in fact made by Dexcom. So, my lords, if we return to the judgment, 152 summarises Abbott's position, which is right. It was a broad construction of coupled in order to catch the infringement. And 153, it's right that Mr Vardy, in one part of his evidence, had suggested that the specification was limited to manual insertion. But it's not right that position was reflected in Dexcom's opening skeleton, because you can see, as I've shown you, Dexcom's opening skeleton accepted that it didn't matter how you inserted the device, and they had their squeeze to cover that point instead. So they were clearly advocating for a construction which included automatic, even though their expert had put in some evidence suggesting that the specification was limited to manual insertion. 154, the judge then turns to Abbott's arguments, and he records at the end of 154 that Mr Vardy had in fact accepted during cross-examination that there were parts of the patent which described automatic insertion as well as manual. And this is important because it's also relevant to the obviousness attack. I did, in fact, go on to try to cross-examine Mr Vardy about what he thought the claim meant, but the judge stopped me. And as your lordships will be familiar, so
It's for the judge to
it's for the
interpret.
judge to indeed. So that was there's no evidence about what Mr Vardy actually thought the claim meant, and the judge decided that on his own, which he was entitled to do. But what's important is it wasn't necessary for me ever to address the prior art from the position that the claim was limited to a manual insertion, because it was never suggested by Dexcom or indeed by Mr Vardy, and we'll come on to look at that in a little while. It was never suggested that the prior art was manual, or that the skilled person would want to make a manual device from the prior art. So it wasn't Dexcom's case. It wasn't a case that I needed to address. And in fact, when he was cross-examined, Mr Vardy accepted that the patent does describe automatic insertion as well. So he went back on the position that he'd set out in his original evidence. So that explains why the point was never discussed with any of the witnesses or indeed in the arguments. Paragraph 156 sets out the passages that we've looked at from Dexcom's closing, where they make it express that they say the claim covers automatic as well as manual. Paragraph 157 is where the judge records our arguments that the construction should not be limited to the specific embodiment in the patent. But this is, in fact, what the judge went on to do. He went on to impose the narrowest construction that was before him, or that he could conceive of, that it was a manual-only based claim, and that was based on his analysis of coupled and operatively coupled. And in 164, he rejected the notion that you could have automatic insertion with the coupling that he had identified, because he said that automatic insertion always requires relative movement. And in doing this, he took some care to identify the housing that he was referring to. That's in paragraph 165. And so in 170,
Your submission is that what he says in 165 is wrong. I mean, you make this point in your skeleton argument, because you make the point that when you look at the way the figure is described, you're told that the housing, the open end of the housing rests on the skin.
yes, it's wrong to that extent. It's not as wrong as Dexcom were in their closing, because they're referring to the housing of a completely different part of the device.
It's the distinction between the light coloured part and the dark.
Yes, absolutely, Mo. And so at 170, he summarises the position, and the mistake he makes is to say, I agree with Dexcom. That's not right, because Dexcom clearly weren't arguing for a manual only insertion construction, but he reaches the construction that he does, that claim 1 is limited to manual insertion, in which the force on and movement of the housing is the cause of the insertion of the needle.
And that's a construction for which nobody was arguing. Is that right?
It's right that Dexcom were including automatic,
And so were you.
and so were we, because we wanted to catch the infringement.
Yeah.
Yes. But of course,
that's the question. Was there any development on the submission in all closing submissions? Because you've shown us the Dexcom opening skeleton, you've shown us their written closing submissions, and they seem to be perfectly clear, as you say. But is there anything in the transcript of the oral submissions that would shed any light on this point?
We have been over those, my lord. We don't think there is. I will make sure I double check that over the short adjournment. But as far as we're concerned, the position in orally is as the judge, or makes no difference to what the judge has recorded here. And Dexcom orally pursued the position that they had set out in writing. But I will.
But even though that was not the construction for which you were arguing at trial, it is not one against which you appeal.
Correct. And I mean, as your lordship's recognised, the judge stopped me cross-examining the expert on this point, because it's a matter for the judge.
Yeah.
I'm not appealing that construction. I don't say the judge was not entitled to reach it. He plainly considered that
the court to construe the claim differently to either party.
Yes, and it does happen. So with that, we turn to Heller, and this is the judgment of paragraph 203 onwards, and 204. The judge correctly characterised the specification of Heller as dealing with two, or at least two configurations. He calls them the main configuration and the figure 32 configuration. And as he records in 204, Dexcom's case was that what was obvious was a combination of the two. And we can see, just by way of introduction, on page 117, the judge has set out the various of the figures of Heller. And figure 2 in the top left corner, that's the starting point for the non-integrated main configuration. So that is just the sensor 42, and you have the substrate 50, you have the traces 52, and the electrodes 60 down at the bottom. And then next to that in figure 12, you have the insertion needle that you can use to insert a sensor such as that shown in figure 2, and you've got different configurations, different shapes of needle at figure 13A, B, and C. And then figure 26 is what the judge calls the insertion gun. That's figure
It's not
200.
just the judge, it's what Heller calls.
Yes, what Heller calls, but yeah, sorry, but one needs to be slightly careful because there's some crossover between the terminology used in Heller and the terminology used in the patent. The same words are used, but they mean different things. So, by way of example, 120 here is characterised by the judge as the insertion needle, but Heller calls it the insertion device. And now, of course, in the claim, the insertion device is the whole thing. In the claim of the patent, the gun. So that's why one needs to be a little bit careful about what one's referring to in each case. But we agree that 120 is the needle.
He's adopted the terminology of Dexcom, as I understand it. What he's done here is, as he says in 208, is to reproduce what Dexcom.
Yes, and I'm not criticising that. I'm just pointing out that one has to be slightly careful at times. And so the other point in Figure 26, you can see the 204 is the carrier, which has got the sensor in it and the needle. And then Figure 28B is an example of a mounting unit 77, and you can see again 120. The needle is there with the sensor below it, ready to be inserted into the body, and that mounting unit has some housing 45 and a cover 76. And then you also see here Figure 33, which we'll come back to, which is the insertion gun 274, and within that gun is the carrier 278, which is the equivalent of the carrier you see in Figure 26, labelled 204. And then at the bottom of Figure 33, you can see 270, the insertion needle or insertion device, as Heller calls it, and the sensor is 272. And all of this is configured with a mounting unit at 276, which slides on to assist with the insertion of the sensor according to Figure 33. So those are the figures. It's probably worth going also to the specification of Heller just for this point, if I may. So can we go to tab 2 of the supplemental bundle, please? I'll pick it up in paragraphs 206 and 207 of the specification. And this is where so it's page 94 of the bundle. And 206 is where this is all in the context of a description of the insertion device. You can see that at paragraph 201 on page 93. But insertion device is in fact just the insertion needle, 120, identified by the judge. So it's not the whole device, it's only the small part which is carrying the sensor. And so if we look at 206, what it says is, it says the force applied to the insertion device, for which the judge calls insertion needle. So the force applied to the insertion needle and or the sensor may be applied manually or mechanically. Preferably, the sensor is reproducibly inserted through the skin of the patient. In one embodiment, an insertion gun is used to insert the sensor, and it then gives the example of Figure 26 as being an insertion gun, and it then goes on to explain how that insertion gun works and all of the ways in which the insertion gun is described are automatic. So there's a cocked or wound spring, compressed air, compressed gas or electromagnet, etc. And then in 207, they describe how the insertion gun may also contain a mechanism to pull the insertion device out of the skin. So this is pulling the needle out of the skin. And again, that's described as using a spring, electromagnetic or the like to remove the needle. So that's 206 and 207 in Heller. And if we can return to the judgment, please. at 209, which is where the judge seeks to summarise these paragraphs and what is described. And he illustrates, he refers to the insertion device, which everyone's agreed is actually just the needle. That's the beginning of 209. And he explains that that can be combined with an insertion gun, one example of which is shown in figure 26. And he says, going over the page, a carrier 204 on the insertion gun drives the sensor and optionally the insertion device into the skin of the patient using a force of various means, which may be manual or mechanical. Now, we disagree that 206 and 207 actually explain that the gun can be manual or mechanical. It's right that beginning of 206 talks about a force being applied to the needle, which may be manual or mechanical. And there's another reference later on in Heller to the patient effectively just inserting the thing with a finger or just pushing the sensor into the skin. So that would be a manual insertion, but that doesn't need a gun. But when 206 starts to descend to detail of the gun, all of the parts, all of the different embodiments of the gun that it describes are automatic, and they require spring, electromagnet, etc. So I'm not sure the judge, I'm not sure there's any reliance on this sentence by the judge, but in case my learned friend sought to rely on it as part of any respondent's notice point, we say that it's not right to suggest that the gun in paragraphs 206 and 207 is suggested to be manual. All of the guns, all of the ways that the gun is said to be embodied are automatic. And it may be the judge was just compressing too much into one paragraph here because, as I say, he doesn't seem to return to it later. So, and the other way one can understand this is if one just looks back at 205.
Of the judgment or
no,
of
sorry,
Heller?
of Heller. Sorry, we're in complicated territory at the moment. 205 of Heller, on page 94. It explains that the sensor is placed within or next to the insertion device, that's the needle, and then a force is provided against the needle and or sensor to carry the sensor into the skin of the patient. And then it goes on to say in one embodiment, the force is applied to the sensor to push the sensor into the skin while the needle remains stationary and provides structural support to the sensor. Now, it's not quite clear how you can push the sensor into the skin without the needle also going into the skin. You'd have to seem to be using something else, but that's, again, all this is talking about is a narrow point about the needle and the sensor, it's not making some more general point about manual insertion generally, in case that was suggested by my learned friend. Then the judge and Heller go on to deal with the part of Heller which describes the integrated sensor and transmitter. And this is embodied in just 5 paragraphs out of the 370 paragraphs in Heller. And it's figure 32 of Heller, and it's picked up in the judgment at paragraph 216. And so what the judge does is he refers to 4 of these paragraphs, which are found in Heller. And in 216, he characterised this as an alternative embodiment of the invention. This is where the transmitter is disposed on the substrate. In 217, he sets out paragraph 230, one possible embodiment of the transmitter disposed upon a substrate, and that's figure 32. And then figure 32 is shown on page 120 of the judgment. And just again running through the features of the integrated sensor, you have 266 is the antenna, 264 the integrated circuit, 260 is the substrate, 262 is a battery, and 263 is the transmitter. And then the conductive traces 266 go down to where the sensor would be placed right at the bottom of the entire unit. And as I say, the judge has set out the 4 of the 5 paragraphs, 229, 230, and then underneath the figure 231 and 232. And this is 231 introduces the concept of encapsulating the transmitter in a protective non-conductive coating. And then 232 is the passage I referred to just now, where Heller suggests that a patient may make use of the device by simply inserting the implantable portion of the sensor transcutaneously and fixing the unit to the skin. In other words, they push it into their skin, and then you could put a plaster over the top of it. And that, because it's got the transmitter and the battery and the sensor all in one place, that might be enough for the readings to be taken on a different device and the glucose levels to be sensed. So that is what is suggested in 232. And the last paragraph dealing with this embodiment is 233, which talks about the ability to have a separate battery so that you could insert the device, and then if you wanted to keep it in place but replace the battery, you could do that by having a separate little battery area on the top.
So this is working without a needle, is that right?
Well, it certainly suggests you might be able to push it in. Yeah, it doesn't give any detail as to how. I mean, I think you'd have to have some sort of device to push it into the body, but you might not need any sort of gun. You could just do it by hand if it was configured correctly, but it doesn't descend to any detail. So back in Heller, having described this alternative embodiment, the specification then in 234 of Heller.
Going back to Heller,
just to show your lordships
Yeah.
How it works.
234.
234 on page 97. So it has these 5 paragraphs about the alternative embodiment, and then 234 says, returning to figure 17, and figure 17 was first introduced in paragraph 226, and that shows the sensor control unit attached on the skin. So the specification reverts back to describing either embodiment in terms of the sensor control unit on the skin. So the other important part of Heller, for the judge's purposes, were the description of the insertion gun or insertion kit at paragraphs 255 and 256. Your lordships, so we're referring now to figure 33 back on page 117 of the judgment. And the judge deals with this in paragraph 222 of the judgment, but if I can also pick it up in Heller as well. So it's in Heller at paragraph 255. And 256. And so your lordships can see the insertion device, sensor, insertion gun and mounting unit can be manufactured, marketed or sold as a unit. For example, figure 33 depicts an insertion device, sensor, gun and mounting unit. And then it goes on to say, in such an embodiment of an insertion kit, the insertion gun can be packaged in a preloaded fashion with an insertion device and sensor mated or otherwise coupled, etc. And then 256, in one embodiment, the insertion gun is packaged in a state where it's ready to thrust the sensor into subcutaneous tissue. For example, the insertion gun can be packaged in a cocked state such that the thrusting force used to introduce the sensor into the tissue is stored in the device as potential energy. And it goes on to say that the cocking could be by compressing the spring. and then about halfway down the page, it explains that alternatively, the insertion gun can be placed in the above described preloaded configuration, but without being cocked. But it explains that the user would then remove from the package, cock it, and then use it to insert the sensor.
If I've understood this correctly, 255 is talking about packaging and selling the various bits of this device together.
Yes.
And when it says which can be assembled as indicated by the arrows, I've taken that to mean that that's the patient who's going to assemble it, having bought it together.
Yes.
It's not pre-assembled at the point of sale.
No, there was some discussion about that amongst the experts, and part of that arises from the requirement to sterilise various bits. And there was some evidence that the common general knowledge methods of sterilisation at the priority date, one method was appropriate for the sensor but would have destroyed the electronics, and another method was appropriate for the electronics but would have not been any good for the sensor. And so one of the ways around that was to sterilise them separately and then put them together. And that's in fact what the Abbott system post the patent did. And so you unwrap the two parts and you put them together and you then insert the sensor. So that was part of the discussion. We don't need to go back into the sterilising debate.
Well, yes, but in answer to my Lord's question, what Abbott did is irrelevant because we're concerned here with what Heller discloses. And it goes on in the next sentence to say it can be packaged in a preloaded fashion. Insertion device and sensor mated wires coupled, weighted sensor and insertion device loaded upon the carrier and with the mounting unit already mated. So I had understood the second sentence to mean that the assembly was carried out during manufacture, not by the patient.
Yes, that's certainly what it's considering.
Yes,
There's a.
I wasn't quite clear about that because 256 is all about the insertion gun. And 255 is the whole kit, the device, the sensor, the insertion gun, and the mounting unit.
Yes, but
and that's I understood that had to be put together by the user. The insertion gun can come ready to go, but you've still got to fit it to all the other bits.
well, I think not necessarily because
Not necessarily. All right. Well,
there's a passage.
if I've set a hair running, let me kill it.
Well, I think it's contemplating both. So in can you see in the middle of para 256?
Yes.
There's a reference to figure 33, and the sentence begins, within the context of the embodiment presented in figure 33, an example of a safety is a pin, that impedes the spring from expanding. Then it says, thus, an insertion kit so embodied can be obtained at a place of purchase, removed from its packaging, and used after removal of the safety pin.
Oh, I see. Yeah.
Without necessitating additional steps. So I think it's contemplating both pre-cocked, and all you do is take the pin out and fire it, or where you have to actually cock it, and that may involve putting parts together as well. In any event, my lords, my overall submission is that it's absolutely clear from 255 and 256, and no one suggested otherwise at trial, that what is being described is an automatic gun, including the spring 280, just in the same way, just as figure 26, which is encompassed within the insertion gun, was described as automatic using a spring or electromagnet, etc. So that we say is what all the experts understood.
Spring 280 isn't actually labelled in the figure, but we can see it at the top.
Yes, indeed. So the judge goes on to summarise Heller in 225 onwards, and he gives equal weight to the two embodiments which we've looked at, and he then at 229 asks the question, how does one go about inserting the embodiment of figure 32, that is the integrated sensor and transmitter. And he summarises the debate in paragraph 230, And he says that the way to insert the figure 32 sensor is to use the insertion device gun of figure 33. And that's the basis upon which he went on to find the claim obvious. And that's because that's how it was argued before him and how it was put in evidence. But as I've explained, the problem with that is that figure 33 is something which describes automatic insertion, as we've seen. And so the judge's summary of the arguments here and the reliance on figure 33 with its automatic insertion is inconsistent with the approach he took on construction, where he said that the claim was limited to manual insertion only. So, my lords, then we get on to the meat of the obviousness section of the judgment, and we can pick it up at paragraph 268, if I may, where the judge sets out the Pozzoli analysis, which is well known. It's not compulsory.
Well, he doesn't do it, does he?
He doesn't do it. No, that's the problem. He didn't adopt it, although he referred to it in a couple of places. He then refers to various other principles of approach. He refers to hindsight in 270, and he cites my Lord Justice Arnold at first instance in 271 in Jardine Consumer Solutions, and he includes.
Can somebody explain to me what was the point of that citation? I mean, there's nothing new in it. While the judgment was reversed on appeal, albeit not on that point, it seems a very odd case to cite.
Well, yes, it was put before him, as far as I remember, and the points there's nothing wrong with the principles in my respectful submission in 102. It may be that the prior art isn't deemed to be a useful starting point. 104, you have to question whether the skilled person would have the motive to take the step in question. That those are all well established principles. And the judge comes back to this in 282 and 283. And he agrees that motivation to modify the prior art is something that has to be taken into account. And 295, he comes back to hindsight. And there's a comment here. We submitted that there are elements of Mr. Vardy's evidence where he descends into hindsight. And in particular, a comment he made, which is cited by the judge in 295, where he said, oh, everything's just a combination of plastic springs and levers or needles. And the judge gives the reference there, which he comes back to later. And we do say that is relevant to the analysis which the judge didn't carry out for Heller. And I'll explain why in a moment, if I may. So just carry on through the judgment for now. 298 is where the judge refers to Pozzoli again, but again doesn't actually do the analysis. And that, of course, is the paragraph that my Lord Justice Arnold asked about. And if I may, again, I'll come back to that in the context of the starting points that the judge uses a little later on. Now, your lordships won't have spent any time looking at the other pieces of prior art that were cited by Dexcom and relied by them. But I do want to spend a short, brief moment looking at one of them, Ethelfeld, because of the reasoning which the judge employs to deal with it, which we say, if your lordships were to consider my learned friend's respondents' notice style points, that reasoning would apply equally to any arguments which might be put in such a way. So if I can just briefly show you Ethelfeld, that begins at page 321 of the judgment. Paragraph 321, page 140. And one can see that the argument on Ethelfeld was similar. It was about whether the skilled person would find it obvious to combine two figures in the disclosure, figures 8 and 13 in that case. And at 322, your lordship can see that part of the argument again was to whether or not the skilled person would want to pursue automatic, in this case, retraction mechanisms, and whether the skilled person would, it would be obvious to redesign Ethelfeld to do that in a satisfactory way. That's steps 6 and 7 in the analysis of Ethelfeld in 322. And your lordships can see some of the figures from Ethelfeld on the following page at 100. There's a figure at 323. This is the device we characterise as the stapler device because it had a sort of there was a debate about whether or not when it was inserted the needle would traumatise the skin because it was going to be inserted as a curve. Now the judge in 323 said that was overplayed, and that's not in fact how he determined that issue. But so he rejected that, but he did uphold the objections to Ethelfeld based on the differences between the retraction mechanism required by Ethelfeld or suggested by Ethelfeld and the retraction mechanism required by the claim. That was step 7 I showed you in paragraph 322. And he deals with this at 328 onwards. So 328 is the depiction in Ethelfeld, and 328 is Dr. Schumacher, that's my expert's interpretation of Ethelfeld. And your lordships can see the device looks a bit like a bunny rabbit's head, and the very top of the, if you push the two ears together, there's a spring in between the ears which springs down, and that can be shown by the green dotted line in Dr. Schumacher's report. And so what was proposed was that the spring was pushed down and it pushed the insertion device and the needle into the skin. But the question was, how do you, if you release the ears of the bunny, the spring pops up again. And the question was, how do you arrange that so as to bring the needle out of the body in a satisfactory way? And Dr. Schumacher here had proposed 2 different ways of doing this, neither of which he said would work. The option 1 didn't retract the needle, it leaves it in place. Option 2 did retract it, but did it in a way in which either it might not go in properly in the first place or it would retract at an angle or a different angle. And that was the debate between the experts at trial. And so in 330, the judge explains the difference between the experts. He summarised what Dr. Schumacher said for Abbott. And then he says, on Mr. Vardy's side, that's for Dexcom, he appeared confident that the skilled mechanical engineer would be able to achieve a working design, but as Abbott submitted, he had not carried through his analysis in his written evidence to a design which could be shown to work. And then the judge goes on to cite some cross-examination in 331. And perhaps if your lordships would just read to yourselves line, you don't need to read all of 331, but line 14 to the end of the excerpt, if you could, please. So the point I was making to Mr. Vardy there was that even though he said it was obvious, he hadn't actually proposed a way in which it would actually be done from Ethelfeld. And the judge took this on board at 332, and he says he doesn't find it was obvious. And of course, the reason I'm making this point is because he didn't do the same for Heller either as far as the judge's construction was concerned, which is what we'll come back to. In 333, the judge says he thinks that by saying it was obvious, but by not proposing a precise way in which this could be done, he says Mr. Vardy was in problem-solving mode. And so he says, I need to ask myself, is it obvious? And he goes on to say that it's not. And he says in 334, which is a general observation of the judge, which we say applies equally to the points, any points my own friend might seek to make on respondent's notice. He says, the second half of 334, instead, and this is a point which has particular force in mechanical cases, it is, in my view, necessary for the party saying a claim is obvious to present an obviousness case which provides the court with a clear idea of what is said to be the end result of the process. We say that is absent from the judge's approach to construction of Claim 1 as far as Heller is concerned. We just don't know how the skilled person would have sought to implement Heller with manual insertion, or indeed whether they would have sought to implement Heller at all if they had been interested in manual insertion, as the judge has required, has construed the claim to require. And so we say that this reasoning would apply to any attempt to reconsider the issue or remit the issue, as my learned friend has suggested. So Lord, with that brief diversion, we get back to the judge's approach to Heller, and picking it up in 336, this is where the judge deals with Dexcom's case. And of course, in summarising Dexcom's case, the judge is summarising a case which considers that the claim includes automatic insertion, and it is not considering a case which is limited to manual insertion, which is the construction reached by the judge. So we say the whole of the approach which follows is flawed because it's based on an approach to the wrong claim. And if the judge had carried out the Pozzoli exercise which he rightly cited, and had identified at the beginning of this obviousness section that he was looking at a claim restricted to manual insertion, he wouldn't have got anywhere near the conclusion that he did, for the reason there was no evidence to support it.
Can I just ask you about 336? The final sentence is that on Dexcom's case, no substantial changes were required. That is to say, no substantial changes in order to make the device that has been claimed by Claim 1.
Well,
so
the device that Dexcom said had been claimed.
Well, I follow. Yes. But doesn't that suggest that your target is the claim of the patent?
The target has to be the claim as it's been construed by the judge.
Well, is it just not what do you do with the prior art?
Yes, that's one way. That's one way of.
He's looking backwards from the patent.
Yes,
saying
that's
what do you need to do to get to the patent? Well, you don't need to do much. Therefore, there is motive, but the motive seems to be deriving from the patent.
Indeed, because he's assumed that Heller reads onto the patent, and of course it doesn't, because Heller is telling you to go for automatic insertion. And so one of my points would be, well, if you start with the claim and you're looking for something that has manual insertion, would you be interested in Heller at all? Because Heller's all about automatic insertion. You might say, well, I'm not interested in that because that's a different way of inserting. That's far too complicated. I'm going to start with something which has a manual insertion. And of course, none of the pieces of prior art which were at trial had a manual insertion. And that's...
That assumes that skilled team at the relevant date would have thought there was a fundamental distinction between manual insertion and automatic insertion. Now, leave aside the question of what's obvious in the mind of the appellant, but why should that be so? I mean, at the end of the day, it's just two different ways of getting a sensor into the right place. And it might be said, well, both when you look at Heller and indeed when you look at Apple, I mean, leave aside the construction issue, that's not a point of great interest. What is of interest is things like how you connect the sensor to the electronics, and all of that. But manual insertion versus automatic insertion, per se, that wouldn't have been seen as being of great moment, which is why when we look at the prior art, we see both exemplified.
Your Lordship might be right. Your Lordship might be right, but the problem is there is no evidence on that. There was evidence that automatic insertion was seen as preferable. That is clear, but no one actually asked themselves the question, if you have a piece of manual, or sorry, if you're looking for something which is manual only, does it matter that you're starting with a piece of automatic prior art or not? And it's just something we were unable to answer on the evidence because it wasn't ever put forward or discussed. And so what your Lordship is proposing is effectively new rounds of evidence and a retrial to discuss those issues. And that it may be that it could be decided that you nevertheless wouldn't put the prior art in the bin just because it's automatic and you're looking for manual. But there's a very real question about how you would amend prior art and what.
To be sure, I mean, but, which is, as I say, a different question. I mean, one way of looking at the case, which I think to some extent corresponds with the judge, is that what is taken to be of interest, at any rate, is one of the proposals in Heller, is the figure 32 combination. So you take the figure 32 combination and you go from there. Configuration, I meant to say.
Yes.
And the question then is, what's an obvious development of figure 32? And your submission is, following the judge's reasoning, it's obvious to develop figure 32 in combination with figure 33, but what that leads you to is something with automatic insertion.
Indeed. And in order to have demonstrated, in order to try and carry out the analysis about would you get to a manual insertion, you actually need to say, well, what would the skilled person actually have done? And that's the point the judge makes in paragraph 334 in relation to Ethelfeld. It's no good just waving your arms and saying, well, it's obvious. You have to say, well, precisely what are you saying is obvious? And that Dexcom never did for a manual, a claim limited to manual insertion. So, my lords, it's clear that Dexcom were proposing automatic insertion as a result of the development of Heller, and we see that in 337, where the judge referred, and this is part of the these are part of the passage where the judge has lifted directly from Dexcom's closing. So it does directly reflect Dexcom submissions. We see in 337 line 4 the reference to spring-loaded insertion, and in 338 there's another reference to spring-loaded CGK type insertion mechanism line 2. And then the judge refers further on in 338, he says the skilled team would expect to use that mechanism adapted as necessary, and he gives a quote, day 2, 145 to 146. And he actually comes back and cites that directly in paragraph 369, and we'll come to that. But that's just to orient your lordships, that's the part of the analysis where the judge says the starting point is figure 33. So that's just so your lordships have that in mind. That's what he's doing in 338. And this is where I'll try and deal with my Lord Justice Arnold's question on Monday morning, and the starting point that the judge used. In our submission, it's clear that the starting point was figure 32 in Heller. And you can see this in his 359, where he goes through the steps that we said were necessary for the skilled person to adopt looking at Heller. And so one has to start with a sensor or a sensor and transmitter, and figure 32 discloses a sensor and transmitter. And the question is then, how do you insert that? And the judge deals with that at paragraph 364. And this is step 4 on page 151, where he says, decide to use figure 33 as the starting point for the new insertion device. So he has started with figure 32, and then he's said, well, how do I insert that? I use figure 33. Now, Dexcom did it slightly differently to the way we characterise it, but we ended up in the same place. So if we go back to Dexcom's analysis back in 337, they started off with the CGK navigator type insertion device, which they say is what Heller was describing. And that is an automatic device, as the judge had found in his analysis of the CGK. And as I showed you, there were no CGK devices which had a manual insertion and an automatic retraction, as the claim now requires. And then you start off with the CGK insertion device, and then halfway through 337, the judge refers to, and Dexcom referred to, the sensor of Heller. It also discloses that the sensor can be combined with the electronics unit. So that's the figure 32 device in Heller. And then in paragraph 338, the judge says, well, the question is then, how do you insert that device? And Dexcom acknowledged that Heller doesn't explicitly teach you to use the CGK spring-loaded mechanism with figure 32, but they argued that it was nevertheless obvious to do that, and that's where we get the quote at day 2, 145 to 146. And so, again, the starting point for insertion is figure 33. And so that's the equivalent of step 5 in the Abbott analysis, which is adjusting figure 33, assuming you've decided to use figure 32. So that's, you get to the same place, but your lordship is right that the judge sets out 2 different ways of doing that. Dexcom started with CGK insertion device equivalent to, and then had figure 32, and then said, well, you'd adapt figure 33 to do that. Our approach was to start with figure 32 and then ask how to insert it. And the judge doesn't seem to decide which one of those is right. But in the end, we say that the same position is reached. And the way that Dexcom approached it in cross-examination, we can see from 368 of the judgment, because what Dexcom did in cross-examination was, first of all, to put the figure 2 embodiment to Dr. Schumacher. So that's the non-integrated sensor-only embodiment. And Dexcom suggested that that would be inserted with the figure 26 automatic needle insertion device. And then they moved on in 369, and 369 says moving on to the figure 33 embodiment, but actually that's a typo. And what is meant there is moving on to the figure 32 embodiment. And that's a typo that's come straight out of Dexcom's closing. And it was a typo that was pointed out to the judge during the closing arguments. I think it was by me rather than by Dexcom, but he obviously forgot about that when he cut and pasted into his judgment. He transferred the typo. So I don't think there's any dispute that in 369, everybody meant figure 32. And then, so he goes on to, this is where Dexcom are putting figure 32 to Dr. Schumacher, and they said he agreed that the starting point for insertion and retraction would be to use the same spring mechanism applicable. And then there's some cross-examination quoted. And then there's a discussion about what changes would need to be made. And this is at 370 and 371 of the judgment. And that takes us on to the discussion about the so-called flagpole device, and which Dr. Schumacher sketched.
Ask.
Yes.
You say that reference to figure 33 and 369 is a typo. It should be figure 32.
Yes.
Does the same apply to 370?
Yes. Well, I'm not sure that. No, I think he's then talking about, well, what do I need to do to figure 33 to insert the sort of device that I've been shown in figure 32. So I think
and that's consistent with the fact that cross-examination quoted has just been about figure 33.
yes, I think
And that is not a typo.
that's not a typo, as I understand. I agree. And my learned friend agrees with both of those observations. Helps. So there's then the discussion about Dr. Schumacher's flagpole device, which he sketched, and how you would insert that into the skin. And then this is taken forward by Mr. Purvis in cross-examination, and that's the section of cross-examination which is proposed at 372. And this is what we characterise as the new case put by Mr. Purvis during the trial. So this is not even Mr. Vardy in problem-solving mode. This is Mr. Purvis in problem-solving mode. And he's put some suggestions to the witness which weren't part of the evidence from Mr. Vardy, but the judge went on to accept those as being reasonable suggestions, and we get to 374, where the judge, quoting Dexcom, says that what would be obvious to do was to arrive at a modified version of the figure 33 device that would automatically insert the figure 32 integrated sensor. And so he says at the end of 374, it satisfied integers 1.7 to 1.10 of claim 1, but it did not on his construction. It only satisfied 1.7 to 1.10 on Dexcom's construction, and the judge had rejected that and elected to go for something narrower, which limited the claim to manual insertion.
That's your main point, isn't it?
That's my main point. And then I have to deal with, well, and the controller agrees with that. And so the question is, well, what does the court do about that? And is there anything that the court should be considering as part of some sort of respondent's notice point? And if so, what is that, and what conclusion would you reach? And so that's really what my remaining submissions are going to be on that. And so, my lords, we say the judge was plainly wrong because he didn't apply his own construction. And as we have pointed out, it was never argued that you would even start with Heller if you were looking for manual insertion. It was never argued.
That's the point I'm struggling to understand. Because that presupposes the skilled person is looking for manual insertion. But why would they do that? I just don't get it.
Well,
that's not how the judge analyses it, and I don't understand that to have been a case that, as you acknowledged earlier, that was debated at trial. You start with figure 32, and I see no reason why the skilled team wouldn't be agnostic as to how it's going to be inserted. But then the question is, suppose they decide to use figure 33, then at that point, you say, they have made a choice because that's automatic insertion. And I get your point that following the judge's logic, you arrive at something which is automatic insertion, and that's not within the claim as he construed it. That I completely understand. But you seem to be trying to make a different and separate point which I don't understand, which is that before you even read Heller, you're looking for manual insertion. And why is that?
Well, because you're applying the Pozzoli analysis. You're identifying what the claim means, and you're identifying the differences between the claim. And part of the question then is...
That may be a difference in the Pozzoli analysis, but that's a separate question.
Well,
it goes back to your own point on motivation.
It does.
You're looking backward from the patent. That's not right. You start with the prior art and the common general knowledge.
All right, my lord. I accept that by doing that, you may be bringing hindsight in.
Yes.
But it all depends. That's the point I'm trying to make, is that we just don't know if the skilled person read Claim 1 as being limited to manual, we don't know whether that would have made them less interested in Heller, because there's no evidence.
At the point where we're hypothesising it, they don't have the patent because it doesn't exist. They only have the prior art. And so the question is, excluding knowledge of the patent and the claim, what is obvious in the light of the prior art? So we look at Heller, we read it with the common general knowledge, and we say to ourselves, well, what's obvious in the light of that? And you've got an argument which, at least to some extent, is uncontested by the controller, that following the judge's logic, there is a development, an obvious development of Heller, but it doesn't actually lead you within the claim as construed by the judge. So far, so good. But as I say, what I don't understand is how you can presuppose that even before they've read Heller, the skilled person is looking for manual insertion. That's the point I'm struggling with.
It depends a bit on whether you identify the problem by reference to the patent, the claim, or whether you...
Well, we don't do problem solution analysis
in
in this jurisdiction precisely because it involves hindsight.
Yes, but there are some cases where the identification of the skilled team is defined in part by the claim of the patent and what the patent is. So there is an element of hindsight that comes in any analysis, because you're trying to put yourself in the right place at the time.
There's a hindsight in the choice of the prior art, for sure. Yeah, you can't get away from that.
And I accept, my lord. I have far stronger points on what is obvious to do from Heller, but I also say, well, we don't know whether it would have made any difference to the overall position of the skilled person. But your lordship understands the point, and I'm not going to dwell on it any longer. What we do say is that it was never argued that if you do start with Heller, the skilled person would conceive of a manual inserter gun, nor was it ever argued that if you tried to implement Heller figure 32 with a manual inserter gun, you would satisfy the remaining integers of the claim, or how you would do that. And that's the point the judge says was crucial for Ethelfeld. Well, I don't know what they're actually saying you would do, and we say the same is the case if you're trying to aim at something with a manual inserter. And so that's why we say there's really no basis to even get off the ground the sort of respondent's notice point proposed by my learned friend, because there just simply was no evidence going to the obviousness of the claim as the judge has construed it. It was not argued below, there was no evidence in support, and indeed the judge made observations explaining why the court should not be tempted to try to decide these sorts of points in mechanical patent cases like this without having actual embodiments proposed before the court. So that takes me to my learned friend's respondent's notice point. And if I can just remind your lordships of how he has put it, and this is tab 3 of the core. This is skeleton, and it's paragraph 75 on page 52.
I take it, Mr. Mitchell, that having tried this yourself in Appimed, you have no objection in principle to the controller taking so-called respondent's notice type points.
No, I'm not. I mean, we could have an interesting debate about whether the controller could take the point, as counsel for the controller seemed to think he could in the Affidmed case, but of course the court rejected it.
Well, not for that reason.
No, indeed. But I don't think that we're content to deal with my learned friend's points as if they were respondents' notice points. I mean, obviously we're subject to the court and what your lordships consider, but I don't propose to object to the arguments, and that's why we've sought to deal with them. And so, my lord, if I can pick it up, para 73, that's where my learned friend accepts that ground 4 appears to have real force. Then he introduces the prospect of a respondent's notice point, and then he comes, he gives 4 points in paragraph 75, and we've sought to deal with these in our supplementary skeleton, but I'm going to try and summarise them, if I may, now. So firstly is paragraph 75A, and this is the housing point, and he says that it might be possible to identify alternative housing in figure 33, which does match the housing that the claim requires and isn't the wrong housing of the sensor which the Dexcom had alighted on at trial. Now, of course, it may be possible to point to other parts of figure 33 and say, well, you can call that the housing instead. There's no evidence of that, but it may be possible to do it as a matter of theory. But the problem with that is it still doesn't turn the concept of automatic insertion into manual. So finding some other housing doesn't actually answer our main objection, which is the judge has applied the wrong construction to the question of inventive step. So figure 33, possible in theory, no evidence on it, but doesn't actually, wouldn't have got the judge home. B, Heller at 207 teaches a spring retraction mechanism. Correct, it does teach it at a high level. It doesn't give much detail, but that's correct. But again, that doesn't answer the point that the mistake the judge made. C is really the heart of the judge's error. And what my learned friend suggests here is that it is possible to find in Mr. Vardy's evidence basis for saying that the judge's interpretation of the integers was obvious. And I'm afraid my learned friend is just wrong to suggest that. No criticism of him or the controller, because it's not easy to come to this after the event, having not been at the trial and not had all the evidence. But I'm going to show you why I'm afraid that suggestion is wrong. So the passages which my learned friend has cited are paragraphs 870 to 872.2 and 1010 to 1016 of Mr. Vardy. And those are found, or some of them are found. I'm going to hand up an extra sheet, if I may, just to apologise that it wasn't included. So if we go, please, to Supplemental Bundle tab 12. And I'm afraid I do have to hand up an extra sheet because, as I say, the last paragraph has been missed out. So if I may. So we're starting off with, this could go in at behind page 202, if your lordships would put it in there, in the bundle.
Sorry, behind page 2.
Page 202.
Oh, I see.
So just to orient your lordships, this tab is from Mr. Vardy's first expert report, and at paragraph 8.57 he introduces figure 33, and your lordships will see that he states expressly line 4 of 857 that figure 33 provides automatic insertion, and he goes on to, he says, then goes on to say the description of figure 33 does not explicitly refer to automatic retraction, but he says that automatic retraction would be preferable. So that's his understanding of figure 33, and obviously the important point is its automatic insertion. Then he goes on, the passages, there's discussion of Heller, and the passages my learned friend relies on are 870 to 872. And this is really the analysis that my Lord Justice Arnold has just been discussing with me, which is where Mr Vardy said, what would it be obvious to do to Heller at the priority date? And there's a discussion, 870, he says we use figure 33 combined with figure 32. 871, he says you can get rid of the mounting unit. 872, he says the skilled person would want to consider how to make the insertion needle retract. He refers halfway through that paragraph, he says, insertion and retraction mechanisms using springs are known in the CGK, and he says the options, as I believe, would come readily to the design engineer's mind, and he gives those in 8721 and 8722. 8721, using the spring in figure 33 such that when actuated, it extends beyond its rest position before relaxing back. So that's an automatic insertion, and then you use the fact that it overstretches to bring back the needle and retract it. And then 872, the alternative, he says you use a second spring beside the one shown in figure 33 to provide the energy for retraction. So both of those suggestions are keeping the automatic insertion, the spring that you can see, and either using that spring to retract or using a second spring to retract. So it's clear in that passage that Mr Vardy is only contemplating that Heller would lead you to automatic insertion. So that's the first passage, the first set of passages relied on by my learned friend. The second set of passages are back at supplementary tab 3. And this begins on page 116, where he is carrying out his comparison of the prior art and the claims. And then the passages that, the passage on Heller begins on page 117 at 10.6. And my learned friend relies on 10.10 to 10.16, and he says specifically 10.13 to 10.16, and your lordships can see those on page 118 of the bundle. So firstly, he deals with housing in 1011, and he is in fact referring to the wrong housing there. He's referring to the housing of the sensor and the electronics. So he's making the same mistake that Dexcom made in their closing submissions. And you have my submissions on the effect of housing. And then you come to 1013, where he talks about the insertion device needing a needle. So he gives evidence in 1013, but again, he's talking about the wrong housing, because you can see that in the second sentence. He says, you need to accommodate the shape of the housing of the sensor and electronics. And of course, the housing in the claim is not the housing of the sensor and electronics. Nevertheless, he goes on, and in 1014, he says, in use, the insertion needle moves from one position inside the housing to insertion position outside the housing, where it penetrates the skin during operation of the insertion mechanism. So even though he's talking about the wrong housing here, it's clear to see that what he's saying is that the needle is not in lockstep with the housing, because it's moving separate from the housing. and it comes outside the housing. So this is not on either construction manual. It's not the construction either the Dexcom proposing or that the judge reached, because it cannot be manual insertion, because he's talking about the needle moving from one position inside to another position outside. That's not in lockstep. That must be automatic. And of course, it must be automatic because what he said earlier about what you would do with Heller is to adopt figure 33 to an automatic insertion of the figure 32 device. So 1014 makes it clear that he is not contemplating something which would coincide with the judge's construction. And then he talks about automatic retraction in 1015, and then he talks about 1016, the two obvious ways to achieve automatic retraction using the spring, and those are the two ways that he's, or a separate spring, those are the two ways we've looked at already. But in both cases, he is contemplating automatic insertion. So there's nothing in this passage which suggests, and there's no basis to suggest in our respectful submission, that Mr. Vardy was saying here that you would get to manual insertion doing anything that's obvious from Heller. Indeed, what he's expressly suggesting is automatic insertion, which is consistent with the analysis he's given in 872 and 873. So, my lords, we say with the greatest of respect, my learned friend is not right to suggest that these passages, or indeed any other passages in the evidence or the cross-examination, can support a finding that it was obvious to get from Heller to a device which has manual insertion. And if we're right about that, then the point that my learned friend makes in D doesn't go anywhere, because if Mr. Vardy never suggested that it was obvious to go to manual insertion, it doesn't matter whether the changes were substantial or not substantial, because he just never made that suggestion. And so characterising the quality of the step is irrelevant, because no step was ever suggested by Mr. Vardy. So that doesn't help. So, my lords, we say this isn't even island hopping. If Dexcom were here trying to argue against it, they couldn't even island hop. There's no dry land anywhere for a respondent to argue that manual insertion was said to be obvious by any witness, or even in argument by Dexcom at trial. And for those reasons, we say that the respondent's notice points, even if it was right for your lordships to consider them, and then even if it's right to consider them, what do you do about it? If there's no evidence, your lordships can't make that decision. My learned friend mentions remittal, but what are we meant to do? We're meant to have a new expert, and
that's difficult to contemplate in circumstances where there's no contradictor.
Indeed, my lord. So we say that in our respectful submission, ground 4 is decisive in this case. My learned friend has recognised that it has real force, and the respondent's notice point cannot and does not get off the ground. We say remission would not be appropriate. The correct course would be to allow restoration of the patent. If there was anything in the point, then it's open for a third party to argue it afresh on some other occasion, properly formulated with evidence from both sides. And that is the only fair way to deal with this issue. And it may never arise, and therefore no further need to trouble the court. But if it was a real point, then it could be raised by a third party, and that's the best way to reflect any remaining public interest points. My lords, as I indicated, the controller also accepts that ground 3 has force, and we, in our respectful position, he's right to do so, and we succeed on this ground for similar reasons. But as I've explained, the ground 3 point involving the identity of the housing all leads to the same place, which is manual and automatic insertion, because coupled to the housing is the way that the judge got to his construction of manual insertion. So if I'm right about ground 4, I must also be right about ground 3, but I also, in that case, I don't need to deal with it because it's the same point made in different words. My lords, just to clarify our position on the remaining points, ground 2 is the Pozzoli point, that the judge didn't make the correct comparison, which I dealt with under ground 4. Ground 1 is the hybrid starting point, which I've also dealt with. We say whatever the starting point, there's no basis in the evidence or the arguments to get to something falling within the claims. And as a final attempt to assist your lordships, and particularly in answer to my Lord Justice Arnold's question on Monday morning, we prepared a claim chart where we set out, if you start with figure 32, what's missing. If you start with figure 33, what's missing. It may or may not be of assistance, but and it may be better if I...
Well, I think it might be of assistance, so
okay.
I will be grateful to see it. Thank you.
Just so your lordship, this was provided to my learned friends. It was late yesterday or yesterday afternoon, so we provided this when we prepared it. And so, my lords, we've just sought to go through the integers and just indicate what is present in each of 32 and 33. It's slightly complicated by the fact that, of course, some of the integers have including or comprising, and they refer to further points. So on one view, you might say that, for instance, integer 1.1 is not present because the sensor electronics do not include all the remaining features, but we've sought to try to cut through that by indicating in green there for 1.1, well, there is a sensor electronics assembly in figure 32. We just put the caveat that the remaining features aren't there. So what figure 32 gives you is effectively a sensor electronics assembly comprising a sensor and a power supply, and then also it's configured for communication because it's got the aerial in it as well to transmit. So that's element 1.11 on the second page. So those are the features of figure 32. And then in figure 33, the gun device, it's obviously because figure 33 doesn't say that it's inserting the combined sensor and electronics, then all we really have in figure 33 is the sensor and the insertion device. We point out for 1.8 that Dexcom and the judge focused on the wrong housing. We've discussed whether or not it's possible to identify alternative housing, but certainly at the level of the judgment, that hasn't been done. And we give you the reasons why we say the other features are not present based on the judge's construction, which I've already been through. Some laws are, if it's necessary to address that any further in reply after you've heard from my learned friend, and I'm happy to do so, but that is a sort of claim chart summary which we hope is of some assistance. So my lords, the final point is ground 5, and this is just the additional point on claims 2 and 3. And this arises because Dexcom were muddled in what...
So this only arises if you're wrong so far.
Yes, it does. So I'll deal with it briefly. Dexcom were muddled in what they identified as housing in closing, and the judge copied that over into the judgment, as we've seen. And so what my learned friend does in his respondent's notice point is say, even if the judge had pointed to the wrong housing, if you start to look at figure 33 for the housing of the integrated unit, sorry, the housing of the gun and not the integrated unit, then you might be able to say that the housing element is satisfied, and therefore that you could see why it might be obvious in his submission to put a cap on the right part of the housing. And we do accept that it may involve less of a redesign to conceive of putting a cap on a different part of the housing than it is to conceive of a redesign that's converting an entire apparatus from automatic to manual operation. But we make the same point that there's still no evidence about that. So the court would have to be deciding it without any evidential basis. But there's a further point, an important point on Claim 2, which is not just that Claim 2 requires a cap, but that it requires a cap which seals the sensor electronics assembly. And that's part of the wording of the claim. And so even if there's basis to substitute Mr. Vardy's foil for a rotatable cap, as the judge seemed to find, neither of those is going to seal the figure 33 apparatus, because as your lordships have seen, it's open all the way up the side and indeed at the top. So there would have to be another redesign of figure 33 in order to seal it all in order to make the cap that you're notionally putting on the bottom to the right housing a cap which is sealing the device. And again, there's no evidence about what that redesign would comprise. You've got the judge's observations about, well, that especially in mechanical cases, you shouldn't be guessing what might be an obvious redesign when there hasn't been an express example put before you. And so we say that Dexcom's muddle on housing does also feed through into this point on Claim 2. And indeed, it might have, Dexcom's muddle on housing, identifying the wrong housing, might well have led to the judge's muddle on construction overall on obviousness, and we don't put the blame entirely at the judge's door, given that Dexcom made the mistake that they did in closing. So, my lords, that's the ground 5 point on Claim 2. And the final point is just to cover off the summary part of the judgment where the judge dealt with the position on obviousness overall, just in case your lordships or my learned friend places any weight on it. And we say, again, that in fact supports our overall submission. So if I can pick it up at 388 of the judgment, where the judge's 5 concluding paragraphs. He says in 388 that many of the arguments made by Abbott on obviousness as a matter of generality had little force when it came to Heller, because as Dexcom submitted, Heller disclosed not just the idea of an integrated device, but considered details of how to implement and deliver such a device. So his view was, well, because following the cross-examination of Dr. Schumacher and Mr. Purves' suggestion, he had come up with a version of Heller which he said was obvious to reach, and it was a specific embodiment of Heller. Then that overcame the problems that he had identified for Ethelfeld, for example. And of course, that doesn't run if you consider the judge got the wrong construction and didn't ask himself the question about whether or not you'd end up with something with a manual insertion. And so this point on 388 falls away when you consider the right construction and the right approach the judge should have taken. 389, this acquittal on hindsight, again, only applies because the judge considers that Mr. Vardy did come up with a proposed configuration from Heller, and what he said was obvious to do from Heller. But again, it's irrelevant that Mr Vardy is acquitted from hindsight if that proposed configuration doesn't fall within the claim as we submit and the controller agrees. The third point is the hindsight point revisited, and this is where we submitted it was hindsight. He rejected that on the version of Heller which he found the skilled person would reach. But he does nevertheless acknowledge Abbott's point about hindsight, and this is the cross-examination I said he referred to later. This is 264 to 265, which is cited in paragraph 47 of the judgment on page 79. This is where he does accept that hindsight can be a problem in mechanical cases. This is where he refers to the plastic springs and needles. So this is further reason why it would be wrong to assume, in the absence of any evidence, that the skilled person would get to a different outcome that is in the claim as the judge construed it, as opposed to the findings he made on automatic insertion. And 391, we say, when you consider the judge's construction, it is by no means inevitable that a practical implementation of figure 32 to figure 33 would fall within the claim. In fact, there was no evidence to support the notion that it would. And so as a result, we say that all of the judge's conclusory paragraphs fall away once you accept that he reached the wrong construction. And his overall considerations, that's paragraph 334 on Ethelfeld, the absence of a actual design from Heller which falls within the claim as he construed it, the problem of hindsight in these mechanical cases, which he accepts in 390, we say all of these point to a finding of non-obviousness of this different construction. And so we say those are further support for our position on my learned friend's respondent notice points. Even if he could get them off the ground and find any evidence that supported him, we say these are all factors which ought to lead to those arguments being rejected. And then finally, my lords, we have 393, where the judge starts to deals with insufficiency, and immediately after his reaching his conclusions on the wrong construction of the claim and the automatic insertion, he then refers in 393 to automatic insertion, and he says that the arguments don't arise due to his decision on construction. So there he has reverted to the correct analysis, and he's correctly identified that having construed the claim as limited to manual insertion, he doesn't need to deal with the squeeze that was argued about automatic insertion. And so we say it's absolutely baffling to spend a whole section of the judgment dealing with the wrong construction, sandwiched between two passages which deal with the construction the judge arrived at. And this overall, regrettably, demonstrates that unfortunately something has gone very wrong with the judgment, whether it's a function of the delay, a function of the copying out of Dexcom's submissions on obviousness, or just a mistake that was made by the judge in applying these different constructions. Something has gone wrong, very wrong with this judgment. There's no basis for your lordships to find it correct for other reasons, because the evidence just isn't there. And so on the basis of everything I've said this morning, we say this is an appeal which, notwithstanding the helpful submissions of the controller, should be allowed. My lords, unless I can help you any further.
Thank you very much. Mr. Austin, do you want to add anything? Yes, Mr. Baran.
Well, I'm grateful. If it pleases, I'll start with a few words of introduction, and then I'm going to go a little more linearly through the grounds that my learned friend, who's chosen for reasons I quite understand, to emphasise some of them over others, but I do want to cover them all off, because the way I've arranged my note is such that some of the questions that have been posed will arise in the grounds on which he's put less emphasis. But a bit of introduction first. The controller appears to assist the court with some of the things that a well-advised respondent might say in response to Abbott's appeal. And so before getting into the substance of the grounds of appeal, there are two themes I propose to spend only a little time on, because I submit that the nature and indeed the extent of what the controller is here to assist with and able to assist with are factors perhaps more relevant in this appeal than is often the case. So I propose to spend only a very short time explaining that. And then the second overarching matter for me to tackle is the role of the judge's delay on this appeal. I will say right now that in this respect the controller will not seek to defend the time that the judge took to produce his judgment, but it isn't enough, of course, simply to say that that delay is unfortunate. We must go into looking, as my learned friend correctly accepts, at what it means for what this court should do. And so I propose to take a bit of time, but only a very small amount of time, given my learned friend's submissions on that. And then I'll get into the substance of the grounds, which I'm going to take slightly out of order and leave grounds 3 and 4 to last, because of course those are the ones on which I take a different position. So the approach to these appeals, my lords are aware of the circumstances which lead to the controller being invited to take part today. He's not a party to this appeal.
Well,
and
can we get this straight?
Yes,
This all started with Halliburton, I think.
it did.
Was Practice Direction 54D in force at that time? Because under that practice direction, where there's an appeal against the revocation of a patent, not only must the controller be served, but he's entitled, not simply invited, he's entitled to appear to oppose the appeal, according to the PD. Now, that practice direction wasn't actually mentioned at all in Halliburton,
No,
which led me to wonder whether it was in force at the time.
I will double check that. My suspicion is not, but that's not
Right.
good enough. I will give you a definitive answer.
Now, if you are entitled to appear, which the practice direction says you are, I don't at the moment think that makes you a party, but you are, so to speak, an entitled intervener, whereas normally an intervener would have to have the court's permission to intervene.
Indeed.
So is that the position? You are
understand it is.
entitled to intervene, but you're not a party.
That's what I understand the position to be, either by that route or indeed because we were invited to intervene by the court. So it'd be rather difficult to be in a position where we were invited to but disentitled.
Yes, my lords might want to see my order in that respect.
Yes.
Tab 11 in the court bundle.
In the core bundle it is.
Yes.
So certainly for the purposes of this appeal, we're entitled to be here, not least because we were invited to be. That's not a complete answer to my lord's question. I think as an entitled appearing party, rather than party, yes, we're entitled to be here, but we're not formally a party to the appeal, is what I understand the position to be. We certainly, which will have ramifications in a little while, are not a respondent to the appeal. And relevant to the answer to my lord's question will often be the reason for which the controller chooses to appear. So, in this case, for example, he's not sought to intervene to advance any interest of the IPO, either in the outcome as regards this patent, or because there is some operational significance to a principle at large, or a large point of law that we consider it's important be resolved in a particular way. None of those apply in this case. We are not here because, and I don't mean this at all flippantly, the controller isn't here because he wants to be here. The controller is here because he sees it as part of his duty to assist to the extent that he can. So we're here to make representations not at all in the interests of the office, nor to represent the office's view as to what the correct outcome is. We're here to make representations against the appeal, such as appear to us to be arguable, in respect of the public interest, which of course is engaged because whilst patents are a very positive force in encouraging innovation, they are at heart a fetter on the freedoms of people persons other than their proprietor. The presence of a patent on a register can reasonably be expected to inhibit the public from doing certain acts, which if that patent is invalid, they should be free to do.
Revocation is a class remedy, which is why there's no requirement of standing.
Quite so. And so for that reason, we appear almost without reference to what we think. This isn't an appeal. There are appeals where the controller asks to come and intervene or takes up an invitation to intervene because there is a particular point at large in which he has an interest, and we're usually very straightforward about what that is when it happens. This isn't one of those appeals. My Lord referred to this court's judgment in Halliburton, and that, as I understand it, is still the position. I did, given the complications on this appeal, I caused inquiries to be made of the Attorney General to ask, by analogy to his appearance in certain cases as an intervener, if there were particular steps, there was a particular policy that should be followed in cases where we understood that certain of the grounds had force, for example. That inquiry produced an ill return, I'm afraid. But I mention all of this only to contextualise the way in which we are trying to assist and how and why it is we've identified the points we have and advanced them in what I accept procedurally is a slightly odd way, given that we're not a respondent and so cannot put in, and I'm afraid, with great respect to my predecessor, Mr Mitchison, I do maintain the position that Rule 5213 is clear. I'm not a respondent and I can't put in a respondent's notice.
You could if you were made a party to the appeal, even though you weren't a respondent to it. But as I say, I don't think the practice direction makes you a party.
Yes.
But it would presumably be open to the controller to apply to be made a party, even though not a respondent, for the purpose of putting in a respondent's notice.
I suppose that might be right if he considered it was in the interest of him or the public for him to do so. Second, I'm not quite sure about the very first point that my Lord put to me, because of course 5213, my Lord has heard my gripes about the rules on respondents' notices before, but this bit is remarkably clear. Rule 5213 says a respondent may file a respondent's notice.
Correct, but then there's a definition of respondent in 52(1), I think, which includes somebody who's made a party to the appeal.
If we're made a party, that must be right, yes. But on my current status, I'm not sure that I could...
Well, that's why I was exploring PD 54,
quite
52D.
Can I just test that for a moment? Would it be a control? I'm not suggesting that this should be done for a moment, just to test the position, to serve the respondent's notice by whatever mechanism, saying the patent judge's order, paragraph 5, should be maintained for the alternative reason the claimed inventions are obvious over one of the other pieces of prior art, for example, elder figures.
Yes. I think it would be, I certainly think there's nothing to stop us applying. Of course, this isn't quite that sort of case. And part of the decision about whether to do that, to take that course, starts from what are we actually able to do? Because the second part of why I go through this is there are enormous limitations on the degree to which I'm going to help you as much as I can. And we've spent an awful lot of time working on this appeal. When I said in my skeleton, grounds 3 and 4 were the product, our responses were the product of anxious consideration, it wasn't just a turn of phrase. This has been a very, very difficult appeal for us for reasons which will be apparent. But that being so, I can't really see in this case, particularly given my learned friend's helpful acceptance that he's happy to take the points on that I have raised in the very generalised form in which I've raised them, it's not clear to me that the controller would necessarily have the resources or the people available to have developed a fuller respondent's notice type argument and run a sort of another almost cross appeal type. It's not clear to me that we have the material or the resources to do that. And those considerations will of course also inform the controller's decision about whether he intervenes in that way or seeks to put in a respondent's notice or something like one, quite regardless of whether it's procedurally available.
And of course, as Mr Richardson acknowledged, it would be open, at least in theory, to a third party to apply to revoke the patent on the basis of the other prior art.
Yes.
Even before you get into different arguments on Heller.
Yes, I mean, one has to be a bit careful with that submission because, of course, one could say that that's a reason not to have an appeal like this at all and just to restore the patent by consent and say, well, if someone's bothered by it, they can go and revoke it. So I don't think that that submission goes too far, but as far as my lord puts it, I accept it. We have to be a little bit careful with that because, as I say, that would be a reason for me to make no efforts at all. And as you can see, it would have been completely open to the controller, I submit, in a case like this to say, well, grounds 3 and 4 identify mistakes that we do think the judge has made. There it is.
Well, the whole Halliburton process, in a way, came about because this court doesn't allow appeals by consent.
Well, previously it did, of course, and so that's quite right. And so it's pretty unsatisfactory, particularly because of that public interest at large, that we take that course.
Because appeals are allowed by consent in other types of cases.
Yeah.
But the point was made in Halliburton that was wrong in this context because it's
because of the public interest. Yes.
Which affects third parties.
And it's mindful of that we've tried to make a bit more effort than simply to say, well, grounds 3 and 4 seem to us to have force. They do.
And we are grateful for that.
Well, and thank you, but there are, notwithstanding that, there are going to be limits to the degree I can't devise evidence plainly, and there are limits to the technical materials, our sort of understanding of the technical materials, no doubt, the development of that. There are going to be limits to it, but I will do the best that I can.
And just to follow that through,
yes.
where you are suggesting a remittal to the judge, that is not something the controller would participate in, I imagine.
Well, my lord, yeah, we should be very straightforward. The first thing to say is we accept that a remittal is a deeply unsavoury prospect.
Well, particularly if there's no counterparty.
Well, I'll come to that bit in a second, but yes. A remittal of any sort is an unsavoury prospect, particularly in a dispute where its resolution has, I think I can straightforwardly say, taken too long already. So we don't have any joy in suggesting it, but I did think it was incumbent, if I'm going to float these points without having the means of being able to ventilate them fully in the way that a party which had an expert witness and a law firm and had been at the trial might be expected to, and trying to suggest that there was some mechanism by which it would matter.
Yes. Well, I mean, it's quite right to air the question, but can you help me on this? The normal course in this court on appeal concerning inventive step is, if we conclude that the judge has made an error of principle, we then reconsider.
Yes.
I cannot think myself of any example in which the matter has been remitted for reconsideration in recent decades. I mean, it might have been done way in the distant past, but casting my mind back over the last 20 years or so, I can't think of a single example.
I'm not going to interrupt my lord with a counter-example. I can't either. I raised the question and quite straightforwardly do it that way. I don't say this is some magic bullet, nor do I put it forward with any glee, but it seemed to me if I couldn't come up with some way of suggesting that this could be taken forward, then there was little point in my making submissions on grounds 3 and 4 at all. And so I wanted to...
But what you've done is to raise matters that we can take into account in reconsideration.
Yes, and I will explain how best I think, it will be an outline only, I will explain how best I think a respondent-like party might invite you to do that. And then my lords will have to decide whether that's on the materials we have is sufficiently convincing. If there is some extremely small gap, or if my lords felt that because a particular point, a small point, hadn't been expressly addressed by the judge, for it to be addressed by this court would wrongly deprive the appellants of a tier of appeal, for example, that might be a reason you might choose instead to direct that the judge answer some very small question based on submissions from Abbott, and if the controller were ordered to participate, no doubt he would. Well, if he were ordered to, he certainly would. If he were invited to, no doubt he would. So that's why I raise it, to try to meet any concern that otherwise Abbott might be deprived of an appeal from a decision that it's a reconsideration of obviousness, but if it's something that the judge didn't consider, because that is the nature of grounds 3 and 4, is that there's something that the judge may have had in his head, we'll never know, but he certainly didn't have it in his judgment. So I think on the nature of my role here, that, my lords, is that clock a little fast?
Yes,
okay,
it's about 5 minutes fast.
That's helpful. In that case, what I'll do is I'll cover over delay, which will ironically not take me very long, and then we'll do the substance, if it pleases, after the short adjournment. So I don't propose to labour the delay point. I'll be as economical as I can. The judge plainly took a very long time to produce his judgment. The trial finished in May 23, and it was the end of June 24 when his judgment was handed down after almost another 14 months. I've been clear, I don't shrink from that, and I'm not going to defend it. But of course, having taken too long to write the judgment can't make an invalid patent into a valid one, and nor can it make the correct interpretation of a document suddenly incorrect by passage of time. The documents say what they say, and that hasn't changed. Where the analysis is focused on the documents, my lords can engage with them on substantially the same basis in my submission as the judge did. The trial judge can engage with them on substantially the same basis at trial and shortly and a long time after trial, one might say, where it is a question of what the documents say. Where it does potentially become relevant is, as my Lord Justice Arnold referred to expressly when granting permission to appeal, is when considering the degree of deference to any appraisal of the evidence by the judge. I will say that it's still worth considering in those circumstances, even if the value in the judge's insight in appraising the evidence of trial is attenuated through passage of time, it can still reasonably, in many cases, and we'll get there when we get there on the grounds, put him in a better position than my lords, because he has his notes from the trial, such as they are, we will never know, and he will have some memories of the trial. So just because...
But you have a transcript of everything.
Absolutely, a transcript, yes, absolutely. But in terms of matters of impression and so on, because one could say, well, we can just give the transcripts to the Court of Appeal, and that's not a good enough answer, because the law has long accepted, controversial in some quarters though it is, that appraising the demeanour and so on of witnesses is an important part of the trial judge's evaluation. So even to the extent that those abilities have attenuated with the passage of time, that doesn't put the judge in the same position as this court, where he's only looking at matters on paper in my submission. I have got notes to take my lords through the phones for you judgment, but given the way my learned friend presented this part of his appeal and delay, I don't propose to trouble my lords with it. It doesn't sound like there's going to be any quibble between us as to the law on the effect of delay. Lady Justice Falk's summary is a neat one which we adopt and binds us anyway. So there it is. I don't propose to take very long with that. I will just, before the short adjournment though, highlight, if I may, one paragraph of my lady's judgment right at the end. So it's bundle page 369 of the authorities bundle, and paragraph number is 328. She says, I'll begin if I may. It is critical that the additional level of scrutiny required of a delayed judgment is not permitted to become a means of enabling disappointed litigants to benefit from a focus on specific points they wish to challenge without a proper regard to the judge's findings on all of the evidence. The judge must therefore carefully consider the judgment and the judge's consideration of the other evidence as a whole, and the parties should, of course, appropriately assist the court in that task, as indeed occurred in that case. Any other approach would not allow the true materiality or otherwise of the evidence on which the appellant relies, and thus the potential for injustice to be determined. So I just wanted to highlight that following her analysis of the law and the particular additional scrutiny which is applied. Having done that, my lords, I propose only to address delay further as and when it might be said to arise when I'm working on the substance of the grounds after a short adjournment. The controller's position in the round is that this delay, while it's regrettable, doesn't of itself make much difference, actually, to the way in which my lords should deal with the grounds of appeal. It doesn't of itself, and to be fair to my learned friend, he hasn't advanced it this way, merit reversing the judge on one of the bases set out in Phones for You. My learned friend simply puts it forward as an explanation of how it might be that the judge has made the errors that he says the judge has made. So having addressed you on that, I'm not going to deal separately with ground 7. And I should say also now that I don't propose to address ground 6 separately either, which is the one about reproducing aspects of the submissions. I dealt with that rather more fulsomely than my learned friend, which doesn't mean to be barbed at all, in writing. And I have very little more to say than that. It's not advanced as a separate ground again. It's not advanced as a freestanding procedural unfairness ground. So it's not a freestanding basis for reversal. And we actually don't consider it properly in this case, without squarely being put as a ground of procedural unfairness for which here there would be, we say, no basis. So unless my lords have any particular questions for me in relation to those two grounds, I'm not going to deal with grounds 6 and 7 any further today. I'm grateful. That then leaves us grounds 1 to 5 after the short adjournment. I'll do 1, 2 and 5 first, as I alluded to before. I'm going to take quite a bit of time on ground 1, in contrast to my learned friend, just because I'm going to deal with lots of the things he dealt with up front in the course of ground 1, including my Lord Justice Arnold's question on Monday, although I will preview that our answers to my Lord Justice Arnold's questions are going to be very similar. So I may be able to take that rather quicker. That then leaves me with grounds 3 and 4, the two on which you have the supplemental skeleton argument in which we've discussed the procedural position. I'll address those last, more or less together and very briefly.
Right, thank you very much. 2 o'clock.
Right, able. No, I think that's.